Texting. Hey, it frequently happens. Lots of people do it. But are text messages allowed in court as evidence? Well, that takes us to this week's case. Involves a woman in Pennsylvania. Her boyfriend was accused, indicted, and was tried for trafficking in drugs, selling drugs. She was then also indicted because the police, when he was apprehended, also got her cell phone and found 13 text messages on her cell phone that indicated she was involved in, or whoever was writing the text messages was involved in, dealing in drugs. Well, when her trial went forward, the DA attempted to introduce this evidence. Say, here's 13 text messages showing somebody who sent these was involved in dealing with drugs. What do you think? Should that evidence come in? Well, let's take a little bit of an analogy. Step back a couple of years. Let's assume that instead of a text message, that there was a note written on her personal stationery. Jane Smith, I want to meet you in such and such a corner and we're going to be able to exchange the money for the drugs, etc., etc. Would that evidence come in to a trial and be able to be offered against the person who wrote it? Well, I think as we all know, it would only come in if it were authenticated, if you could prove that the person who was accused actually wrote that note. How do you do that? Well, they've got their name printed on the stationery, but what about the handwriting? Well, now we get into handwriting experts, and somebody has to prove that the handwriting actually is that of the person who wrote it. In short, it has to be authenticated. But what about text messages? Same thing or not? Well, the court said that, in fact, same thing does apply. That whoever wants to get that evidence in must show that the person who is accused, in fact, did write those text messages. In this instance, the woman testified that she did not have exclusive use of her phone. Other people had access to the phone, and therefore the judge said to the district attorney, you have to prove that she, in fact, did send these text messages. All right, now there are a variety of ways in which that can be done, but we don't need to go into that right now. The point is very simple. Even though we're moving forward with different technology, many of the rules that developed a long time ago still apply. And in this instance, in order to get a text message in as evidence, either in a criminal trial or in a civil trial, you must show, if you want that evidence to come in, that the person who you are saying wrote it actually did write it. And how do you do that? Well, there are a variety of ways to do it, but you must show that. We must have evidence that is true, evidence that is authenticated in this instance. And why? Because it's only with actual proof that is substantial that someone can either be found guilty or found liable if it's a civil case. Okay, we bring you this case as we bring you cases every week, so you understand how the law works. I'm David Allen.